We are now in session. Please be seated.
Well, good morning and welcome everyone. It's wonderful to be able to include this ceremony as part of the celebration of the court's 50th anniversary. Sitting with me on the panel this morning are, to my right and your left, our honored guest, Chief Justice John Greaney, and the court's second Chief Justice. And to my left and your right, and oddly configured in the role of the junior member of this panel, our dear friend, Chief Justice Armstrong, the court's fourth Chief Justice. I want especially to welcome Chief Justice Greaney's wife, Susan, and sitting with her at council table is our own Patty Malone, to whom Chief Justice Greaney served as a very valued mentor. Today has been a very long time in the making. Our program, again, will be brief but celebratory. It'll include remarks from Chief Justice Armstrong, who served alongside Chief Justice Greaney as an Associate Justice, and under his leadership, after Justice Greaney was appointed as Chief. And then some reflections by our guest of honor. Without further ado, Chief Justice Armstrong.
So I was the junior judge when I came to this court. And so I'm used to being in this position. I was junior because we were all appointed at roughly the same time. And we set seniority among the original 6 judges by a pattern. The chief has to go first. The former judges would go second, and those of us who weren't judges would go third in order of age. And that left me at the bottom part of the order with Judge Goodman and Judge Grant, and then Judge Armstrong. So, but anyway, it's interesting to be back in junior position. I should begin by saying that I know John Greaney really well. John came from my town. We were in the same neighborhood. I peddled papers to his house. I never saw John in any of that. I was always dealing with his mother, who I might say was not only a lovely woman, but tipped very well. When John, after law school, went with a law firm in Springfield, he clerked for a firm named Ely King, and Ely was Governor Joe Ely of Massachusetts, who lived and he was on my paper route also. And he was not a good tipper. And my mother explained it, that the Irish were the good tippers, and the English or the Yankees were didn't get their money by giving it away. It was so on that heavily racial note, I begin my talk. I didn't know John, and the reason was that I was going to the public schools and he was going to the parochial school, St. Mary's in Westfield. And I went to St. Mary's also, but on Sundays. I was in the public schools, so I never ran across John in any of my classes. It's lucky I didn't, because if we had, I ended up valedictorian. He ended up valedictorian, and I'm sure he would have beat me if we were going to the same school. we were roughly the same time. I was, I think, 3 years older than John. And but when we went to different colleges and law schools, after graduation from law school, I went into a clerkship, and John went. I don't think you did a clerkship. I think you went right to Ely King.
Right.
And so he he worked at Ely King for roughly 10 years or so. And it was in 73, something like that. He was appointed to the Hampden County Housing Court, and made quite a bit of news there. I used to read his opinions in Lawyers Weekly. There weren't many housing court opinions there, but Lawyers Weekly printed John's, and he was obviously a person of some talent, and he was only about 3 years in the housing court when a new governor, Michael Dukakis, appointed him to the Superior Court. And that was around 1975. And he had an interesting 3 or so years as a Superior Court judge. I remember, among other things, he issued a decision that put down a teacher's strike at some school. Was it Framingham?
No. It was in Dedham County. I can't remember the town, but yeah.
Anyway, it's as you know, teacher strikes are illegal in Massachusetts, and John did what he had to do and joined the strike, and then had to set about figuring out enforcement for the recalcitrant defendants. And I remember that case followed him to the appeals court, which he came to in in 1978, 3 years later, because on the anniversary of the strike, he would get hate mail and threats in the mail, and that followed him into the appeals court. And it shows you the bitterness that is involved in some of those strike-breaking activities, and judges take a lot of abuse for them. Well, when John came to the appeals court, he was where I already was, because I had followed a different route. I never worked in a private law firm. I went from being a law clerk to being on Governor Volpe's staff, and I worked over at the State House for many years as governor's legal staff and attorney general's office, and then Governor Sargent's counsel. So I had been appointed to that original appeals court. We had been in existence about 5-6 years. It was evident that we simply did not have anything like the number of judges we needed to do the work. And Governor Dukakis, to his great credit, appointed for simply wonderful appointments to the appeals court. It was evident from the beginning. And the first of them was John. He got through the legislative process and was got his approval from the executive council first among that group. And then came Charlotte Peretta, and then Raya Drebin, and then Rudy Cass, who was the last and who was really worrying what would happen. So Governor Dukakis's term was then ending, and he was concerned that if Dukakis were no longer governor, and a subsequent governor tried to block his appointment, whether the council's approval could be withdrawn and a new nominee submitted. But anyway, it worked out well. But anyway, John was the first of that group, and it was a terrific group. Okay, thank you. When John came to the court, I remember I talked with Raya Drebin. Raya Drebin has a very exalted position in the appeals court. She was a simply marvelous judge. And she said the first day she sat with John, cases were assigned, and the next day he arrived in her office with his completed opinion on one of those cases. And she said, this has to be a shabby piece of work. And she looked it over and said, it was simply wonderful. It was a very good opinion. And coming from Raya, I know it was a very, very good opinion. And I should say also, coming from John, I knew it had to be a very, very good opinion. But she immediately identified the qualities of speed, very facile writing style, and just the quality of the legal work that went into doing the opinion. John possessed all of these to an extraordinary degree. He served for about 5-6 years as an associate justice when Allan Hale had to retire under the mandatory retirement law. And so we had a vacancy in the Chief Justice position. So John was itching to apply for the Chief's position, and but he came around. I remember talking to each one of us who were of each of the associates, and to encourage us. He said, because you have seniority over me, it would be appropriate for you to be appointed chief, and but none of us was interested, which I can't really recall why that was. I think we all thought we had so much work to do, we couldn't take on the additional responsibility of being chief. And back at that time, I think it was a $2,000 pay difference. It was hardly worth the money, even in the better dollars of that day. So anyway, John was appointed chief, and became our chief in 1984. As chief, it was certain qualities were evident. One was that problem solving became very easy. When you're chief, a lot of problems come to you. Staff have problems, the judges have problems, and John had a way of dissolving all problems with his sense of humor. People would go in with weighty problems and they'd come out laughing and feeling it was not a problem at all. This is a great quality for a Chief Justice to have. He made very frequent visits to the offices of the Associate Justices. He would simply pop in, inquire if we had any problems at all, do whatever he could to help us. It was really quite amazing that he made it so easy to work for the appeals court. And I think the storied collegiality of the appeals court sort of began during John's term as the second Chief Justice of the court. He had some very profound accomplishments as chief. One is quite early on, I think it was in 1985, the year after he became chief, very quietly he got the legislature to pass legislation that gave the judges the power to hire their own clerk. We never had that power. It was in the legislation that created the appeals court. The clerk of the SJC for Suffolk County would act as clerk for the appeals court. This was particularly anomalous because very soon after our creation, we had 3-4 times the budget, the dockets entries that the Supreme Judicial Court had, and who they appointed as their, I think it was an elective office actually at that time, and it was held by a Democratic state committeeman, and it was really quite essential that we be able to name our own clerk and control our own clerk's office. Well, the judges on the court were amazed that John accomplished this. Figured we never had a chance in the legislature against a Democratic state committeeman. But it never became a big legislative fight. John simply slipped it through sometime during prorogation. And the next morning, the clerk of the SJC for Suffolk County discovered he was no longer the appointer of the clerk for the appeals court. The second thing was that, and Fred Brown mentioned this to me yesterday, that he was the one who initiated the IT developments in the appeals court. He got together with Rudy Cass and Raya Drebin, who were the only judges of that new group who had come from large law firms, large Boston law firms, Brown Rudnick in Rudy's case and Palmer Dodge in Raya's case. And to get together with those offices and find out what the problems, discuss with them what changes had to be made in the appeals court's clerk's office procedures to bring us up to date with the law firms who were miles ahead of us in all matters having to do with computerization. And he got, and that way he prepared legislative requests and got money for a computerized IT system for docketing in the appeals court. And he also addressed the problem of too few judges to do the work, and was chief when the legislation passed to add an additional 4 judges to the appeals court, bringing the number from the originally it was 6, then the 4-judge addition that he was part of, and then he put in for another 4-judge addition. And because of problems that the governor had, and his attention was turned elsewhere, I think, to the presidential race, the appointments did not get made for really quite a long time. By the time they came to the court, and the addition of 4 judges was obviously so far insufficient to handle the problem. Nevertheless, it was a big accomplishment. By the time the judges were actually appointed, another development had arisen that Chief Justice of the Supreme Judicial Court, Edward Hennessy, had reached the mandatory retirement age, and he retired in 1989. This is now 4 years after the appeals court after John had become chief of the appeals court. So there were 2 appointments to be filled on the SJC. One was as associate judge, and one was as chief, and one was as if the chief were named from within, place for an associate judge. Well, as it worked out, the chief was appointed from within. It was Paul Liakos, and but then that left the associate vacancy, and John went to the SJC. In all of this, John produced issued opinions that had a writing style that was simply incomparable in terms of legal quality. Lawyers especially appreciated John's work. It was get the highest accolades. I don't know how much further I can go, but I think of a particular case that to me demonstrated why John, in a way, as I think back to it, losing John as chief of the appeals court and making him an associate in the SJC lost a lot of his talents. His talents as chief were extraordinary. I tried my best to do what he did when I became chief 10 years later. But it was a hard act to follow. So those talents that John had of leading an organization were lost, and I always think, that was a big loss to the judicial system. Nevertheless, it put him in the highest court for writing decisions, and they were marvelous decisions. They often had a quality that distinguished them from ordinary SJC decisions. I'm thinking now of a particular case. It was big case at the time, the Goodridge decision, where it was the one that authorized same-sex marriage. And people often think, well, the majority was spoken for by Chief Justice Marshall, and there were some other opinions. Well, when you look at it, it's not exactly that way. Chief Justice Marshall wrote for 3 people on the court. Justice Bob Cordy wrote in dissent for 3 judges on the court. And the vote in the middle was John Greaney. John wrote a very short but decisive opinion, concurring in the result reached by the majority, but saying that he would have got there by I think he said that the case is decided most directly by reliance on the Equal Rights Amendment of the Massachusetts Constitution, which guaranteed no discrimination on the basis of, among other things, sex. And this was a discrimination on the basis of sex, something which he proved in his short opinion beyond question. But at the end of his very short opinion, he wrote a paragraph that I think of as one of the things that distinguishes a legal opinion from a great legal opinion. He ended his opinion by saying, "I am hopeful that our decision will be accepted by those thoughtful citizens who believe that same-sex unions should not be approved by the state. I am not referring here to acceptance in the sense of grudging acknowledgement of the court's authority to adjudicate the matter. My hope is more liberating. The plaintiffs are members of our community, our neighbors, our co-workers, our friends. As pointed out by the court, their professions include investment advisor, computer engineer, teacher, therapist, and lawyer. The plaintiffs volunteer in our schools, worship beside us in our religious houses, and have children who play with our children, to mention just a few ordinary daily contacts. We share a common humanity and participate together in the social contract that is the foundation of our Commonwealth. Simple principles of decency dictate that we extend to the plaintiffs and to their new status full acceptance, tolerance, and respect. We should do so because it is the right thing to do."
Thank you, Chief Justice Armstrong, for those beautiful and profoundly moving remarks. I now turn to our guest of honor.
Well, thank you, Chief Justice Green, and thank you, Chief Justice Armstrong, for those remarks. I'll pay you the agreed-upon amount later. When Monique called me about this honor a few months ago, I initially said no because I really thought there were others who should be up there on the walls. And I don't know why I was being signaled out. But then when she told me that Chief Justice Armstrong was also going to be honored with a portrait, I changed my mind because as Chris told you, we grew up in the same neighborhood. We had a lot of common contacts with us. He was our paper boy, and so on. I was accepted to Yale Law School but didn't go. He went to Yale Law School. So our paths crossed frequently. And when it came time to take the bar exam, I borrowed his bar review notes, and in the margins was this tiny calligraphy-style writing that summarized whatever was on the page in one or two sentences. And to this day, I call them the Armstrong nuggets. 4 of us were appointed to the appeals court, including the first 2 women, Raya Drebin and Charlotte Peretta. Mike Dukakis had lost the governorship, and word came down that Ed King, who was the new governor, they were 2-year terms back then, was going to block our appointments and not get us confirmed because he wanted the appointments for himself. In those days, and probably still to this day, you went around to see each governor's council and asked him or her humbly if they would vote to confirm you. So I did that with the full expectation that one of them or more of them would tell me that no, the appointments were going to Ed King. And when I got to the counselor from Worcester, a gentleman named Truro, he looked at me, and after we chatted, and he said, I don't give expletive deleted about you, but I want your seat on the Superior Court for Bob Mulkern, who had defended him in an extortion and bribery trial and gotten him acquitted. So that led to my confirmation, and the council could not refuse the other 3, so they went through as well. I succeeded Allan Hale as the chief, and those were gigantic footsteps to fill in because he really was the founding father, along with the associate judges of the court. And he sat with us for a while, or I sat with him rather, when I was an associate justice, and he was a great legal mind and wrote great opinions. The caseload of the court expanded greatly during my tenure. I was able to add the new judges that Chris talked about. I was also able to add more staff lawyers, and that helped immensely. I was helped in particular by the addition of 2 former SJC judges who could sit on recall with us, and some of you will remember them. One was A.M.I. Cutter, and the second was Ben Kaplan. If you go back and read Cutter's opinions, they are very short and very synoptic. If you read Kaplan's, they read almost like poetry. They're very lyrical, and they're wonderful pieces to read. The one case I remember distinctly with Cutter was he was sitting with me. I was chief, Joe Warner was the other judge, and M.I. Cutter, and we were dealing with the ownership of the Boston Red Sox because Buddy LaRue, who was a limited partner, tried to stage a coup and displace Gene Yawkey and John Harrington, who were the general partners. And of course, you can't do that under the partnership, that particular partnership agreement. And they got blown out in the Superior Court by Chief Justice Lynch. So the appeal came to us. The SJC didn't take it. The courtroom was filled with practically every prominent lawyer in Boston representing one or the other part of the Red Sox ownership. And when the argument ended, Cutter leaned over to me and said, ask the lawyer one more question who was making the final argument. And I said to the lawyer, I have one more question for you. And he said, yes, Your Honor. I said, what are they going to do about the pitching? Well, 2 weeks later, a short article appeared in Sports Illustrated that indicated that a judge had finally figured out what was wrong with the Red Sox. had told them what to do to correct it. During my tenure, and this was not mentioned, I had the honor of co-chairing with Ruth Abrams on the SJC, the gender bias study, which took a full year or year and a half of our work. You can read the report, and some of you probably have, and some of you might have been interviewed for it. But it was an enormous undertaking at the time, and frankly, when we finished, I was shocked at what we had found about the state of women in the Massachusetts judiciary in terms of not being promoted, not being appointed to the bench, not getting equal pay, and a number of other differentials that were just really not proper at all. So we issued the report, and it was fortunate enough to be accepted, and most of the recommendations were implemented. Judge Armstrong mentioned that we got our own clerk during that tenure. John Powers, who was the one he referred to, was both clerk of the Supreme Judicial Court for Suffolk County and clerk of the Appeals Court. And it was clear that he had to go because our caseload had grown so enormously. So we went over to see the powers that be in the legislature. The first was Speaker Finner, and Charlotte Preda went with me, and he quickly agreed that he would sign on to and get the legislation through the House. The second leader was more problematical, and that was Senate President Bill Bolger. So we went to see him, and we were armed with a certain piece of information, Chris, and it was this, that in his capacity as running the Suffolk County Courthouse Commission, which at the time hired the janitors and others that cleaned the courtrooms at night, he working on that staff was one Whitey Bolger. And Whitey had a habit of coming in, apparently, and spending about an hour, and then ducking out to engage in other activities that are now well known that weren't quite consistent with the duties of a janitor. So Powers fired him. And this was to the eternal hatred of Brother Bill. So he promptly agreed that we would get that, and John Powers was replaced, and we promptly appointed Nancy Foley as the first woman clerk of the court. I'm going to conclude now by thanking a couple of people. I want to thank the hardworking staff attorneys that we had back when I was on the court and have been on the court consistently, who wrote the memoranda, who came in and talked to us if we had a problem with a decision and helped us resolve that problem. I want to thank the law clerks who worked with me and are working with the court now. They are among the best and the brightest in the bar in the Commonwealth and beyond. I want to thank the hardworking staff of the appeals court for all that they do day in and day out. And I want to thank the court officers for all the help they give us and how they really are the face of the court when the first people coming in to hear oral arguments or to see the court are greeted by the court officers. I can say when I went to the Supreme Judicial Court that this court and its judges and its decisions were held in the highest degree of respect. And many times when we had discussions about whether we should take further appellate review, the bottom line would be this is a good appeals court opinion. We shouldn't take it and change one word of it. So that's all I got to say. I want to thank you all for coming again. I want to thank the court for giving me this honor. And I want to finish by saying, God bless this honorable court.
Thank you, Chief Justice Greaney. As I mentioned at the beginning, today has been a very long time in the making, and you said that it was several months ago that Monique reached out to you. In fact, it was a couple of years ago. It began when Justice Peter Agnes came to me to report that he had located a portrait of Chief Justice Greaney hanging in a courtroom in Western Massachusetts and thought it likely that we could get permission to have it reproduced for display here at the John Adams Courthouse. And by the way, for those of you who are wondering about the contrast between the display of the portrait during these proceedings today in contrast to the ceremony that we held just a couple of weeks ago for Chief Justice Armstrong, the reason is that because this image has been on display in that courtroom in Western Massachusetts for quite some time, it seemed rather silly to pretend that it was a great revelation to pull the blanket off of it during this ceremony. And we followed the same procedure, of course, with the ceremony we held shortly before the pandemic for the portrait of Chief Justice Warner that hangs behind my left shoulder. But shortly after we had that conversation and after Monique had extracted the permission from Chief Justice Greaney to undergo this honor, the portrait that you see here in front of you arrived in my office, where it remained still in its carton, leaning against a wall for several months as we thought about when we might be able to schedule a ceremony like this. And in fact, we held the event that I mentioned for the portrait of Chief Justice Warner on February 25th of 2020. And then, COVID. So the portrait remained in my vacant office, leaning against that wall for over a year, while I, like all other appeals court personnel, worked remotely due to the pandemic. And when we returned to the building in the summer of 2021, it was clear that while we might resume in-person arguments under strict safety protocols, we wouldn't be holding public ceremonies of any kind, much less like this, for quite some time. Eventually, with Monique's assistance and the assistance of the court officers, we moved the portrait to safe storage while we waited to find a time. So it is indeed a pleasure, finally, to be able to hold this event today. So now it is my great pleasure to formally accept the portrait on behalf of the court. It will hang on the wall behind this bench, flanking the portrait of the court's first Chief Justice, Allan Hale, along with the portrait of Chief Justice Warner. Positioned as they are, the court's first three Chief Justices, who, by the way, could have sat together on panel during their time overlapping in their service to the court. The court's first three Chief Justices will shadow the panels that sit on this bench in seniority order. I want to thank the court officers for their assistance in managing this proceeding, our clerk, Joe Stanton, for clerking the session, our IT team, including Jeff Travers and Tom Carter, for setting up the live stream that has allowed those who could not be with us today, or even those who are sitting in the overflow space on the other side of the courthouse, to allow them to follow these proceedings online. I also want to thank those who contributed to the cost of producing this portrait, including two of our staff members who are in the courtroom with us today, Patty Malone and our clerk, Joe Stanton, who both came to me and said that Chief Justice Chief Justice Greaney had been such an important mentor to them early in their careers. I want especially to thank retired Appeals Court Justice Peter Agnes for having the vision and foresight to realize the importance and value of recognizing the court's history in this way. And with that, these proceedings come to an end, though I encourage you all to remain right where you are for the next event on our 50th anniversary program, a panel discussion on women at the Appeals Court.